Okay, so we're going to have a whirlwind tour through other kinds of immigration benefits that kids in juvenile court may qualify for. And again, during this section, the examples I'll use are primarily going to be using children as examples. But the thing that's important to remember for these kind of immigration benefits is that these are kind of benefits that may be able to benefit or people benefit an entire family, or that there may be that the immigration relief is not just limited to children, like special immigrant juvenile status. Clearly only the child in any of the proceedings will be eligible for this relief. But the thing that's useful to know about family-based immigration, VAWA, U visas, T visas, is that these are forms of relief that parents may also qualify for. So if you're a parent's attorney, it's probably very helpful to realize that and to know that while you might not be in a position to carefully evaluate a person's eligibility, certainly there are a lot of immigration practitioners who you may be able to refer people to for help with the immigration side of their case. And the thing that's important to remember is that you may have situations where, say you represent a child and they don't qualify for special immigrant juvenile status, maybe they don't qualify for these forms of relief on their own. They may still qualify as a derivative on their parents' application. So it may behoove you to work together with parents' attorneys or for everyone in the case to confer on these things, because you may actually be able to help an entire family who really qualifies for immigration relief to access those services. And you could have a parent who may qualify for a benefit and can include a child on an application. Similarly, you may have a child who qualifies for a benefit who can include his or her parents. And so in a lot of cases, you may find that parents may have difficulty complying with court plans or with remedying some situations in the home that may be difficult either because they feel that they can't leave an abusive partner or they have difficulty working, they don't have a work permit. So if you know about these kind of immigration forms of relief and parents and children may qualify, it may put the whole family in a better situation to comply with the court plans, to have a closed juvenile court case where everyone has resolved issues that have come up. So I'll use kids as examples, but again, they won't necessarily be limited to children. I'll try to point out the places where adults may qualify. Now again, in most of these forms of relief, there's not going to be a special juvenile court stage. So unlike special immigrant juvenile status where you need findings from a juvenile court, with these forms of relief, you may not need anything special from the juvenile court, but it may be the family's involvement with the juvenile court that helps someone to see that they qualify for this relief. The one exception to that is something called a U visa, and I'll spend some time talking about that. It's a special visa available for crime victims, including victims of domestic violence. And it is possible, one of the requirements for a U visa is that you have a certification signed by law enforcement saying that the person has been, is being, or will be helpful in the investigation of the crime. And one of the people who can sign these certifications are actually Child Protective Services, that the federal immigration regulations clearly state that Child Protective Services can certify in these cases. And the other, the regulations and also state that judges, state, local, or federal judges can sign these certifications. So you may have a case where a child doesn't qualify for SIJS, but it may be that the juvenile court judge could sign a certification that would make the child eligible for a U visa. So I'm going to go over the family-based, violence against women, U visa, T visa, asylum, and you're going to see we're not going to go over these in a level of detail anywhere close to special immigrant juvenile status, but really this is just designed to give you an overview and for you to understand that there may be more that you would need to learn or a place to refer the clients if they look like they'd qualify. Once we go over this, and I'm going to go over pretty quickly, then we're going to have a breakout session where I've given you hypotheticals, and they're designed to help you try to identify what forms of immigration relief the person might be eligible for. They're not designed to test if you know where to mail the applications. They're really about issue spotting, and so I think you'll probably break out and talk to the people that you're sitting with at your table about that. Then we'll have a break. Okay. So family-based immigration, again, this is the most common way that people immigrate to the United States is through relationships with, legally immigrate to the United States is through relationships, family relationships. And so it's important to know that US citizens and people who are lawful permanent residents can try to petition to help family members to get lawful status here. And that can include family members who are back in their country of origin, but it can also include family members who are already here in the United States, even if they're here without permission. Now, if they're here in the United States, it may make their case infinitely more complicated, but it doesn't necessarily bar them from immigrating as a family member. What you should know is that U.S. citizens can help spouses, children, and this is including stepchildren and adopted children, sons and daughters, which under immigration law basically means children who are above the age of 21, then also siblings and parents to immigrate. U.S. citizens can help their family members come here more quickly. So if you're considered an immediate relative of a U.S. citizen, that means that you aren't subject to any lines or quotas, but that you can immigrate more quickly, and that basically includes spouses, parents, and unmarried children, so under 21. Lawful permanent residents can also help family members to immigrate. The way the immigration law is set up is that U.S. citizens sort of get priority on speediness, and then lawful permanent residents who are helping family members often have to wait a much longer time to help those family members to immigrate. And I'll give you some examples of exactly how long, but you'll probably be somewhat surprised about that. I briefly want to talk about, in the family-based immigration part, something that definitely comes up, which is the whole issue we talked about before about adoptions of children and how can that work for immigration purposes. One thing that I realize in my reading of the entire Nebraska Juvenile Code and adoptions codes is that there is a requirement in Nebraska statutes that places additional not burdens, but there are additional requirements when you're filing an adoption petition for a child who's born outside the United States. And I put the citation here. Basically, you need to have a statement, and it's worth looking at the statute if you have a case like this, but a statement from the child's country of origin about the situation of the parents, whether the parental rights have been terminated, whether the parent has given up the child for adoption, and then also some kind of written consent by an agency that has placed this child for adoption. What you might come to see is that these requirements may be very difficult to meet in certain cases, because you may have cases where children have been in the U.S. like 10 years. They never were placed through this kind of licensed child placement agency. They came here when they were 1, and they never had any statement from their home country about their parents or their immigration situation. So I have tried to find out how this plays out in practice, and I haven't been very successful in learning about any particular cases that have come up. Has anyone here handled a case of a foreign-born child who had to try to comply with these requirements? Is that? No? Okay, so I wish I could tell you more about how the juvenile courts deal with this, but it seems, I think it's a relatively new provision, not within the past year, but relatively new, but it's something to be aware of. I imagine that the law, although I haven't looked at legislative history, I imagine that it was probably designed to try to comply with certain international norms and agreements about international adoptions. And it may be that if you run into this situation where you can't easily comply with these requirements, I would imagine it's conceivable that you could try to immigrate the child through special immigrant juvenile status and then ask the court for an exception to these requirements for an adoption, because what you've done is already dealt with the child's immigration situation, and that this provision seems designed to make sure that the immigration issues will be addressed. And if you've already addressed them, then perhaps you can get around this. But I haven't run into anyone yet who's had to deal with it. The other thing to know is that in early 2008, the Hague Convention, Adoption Convention, went into effect and has created incredibly complex rules for immigrating children who are from other Hague Convention countries. And when I called immigration practitioners, because I called to ask if they had special expertise in Hague Convention, everyone is sort of afraid of the Hague Convention. It's very complicated. But it's something to know that in the past, it may have been, inside or outside Nebraska, not too difficult to have a foreign-born child adopted here and to do an immigration process for them. But as of last year, the forms you need to fill out, the involvement in the child's home country has become much more, the requirements have become much more clear and much more complicated. I guess what I would say is that if you have a case of a foreign-born child who's being adopted, you really want to make sure you have an immigration practitioner with experience to be consulting on the case, because you want to avoid the problems of having a completed adoption and then adoptive parents years later finding that they have an undocumented child on their hands. Now, how someone would file for a family-based immigration is they file something called an I-360 petition. It's a petition to classify a family member as an immigrant, and includes, it's pretty straightforward, fee, proof of relationship to the Immigration Service. But the timing of the adjudication, the timing of the next step in the immigration process is really dependent upon whether people fall into something called a preference category or not. And I am always concerned about even bringing up this topic because it's really complicated. But the reality is that if you turn to page 71 and 72 in your materials, you see something called a Visa Bulletin from the Department of State. And what this Visa Bulletin shows is that it says that for people who are not immediate relatives of U.S. citizens, so not the spouses, the parents, the children of U.S. citizens, but for people who don't fall in that category, they probably fall in something else called preference category, and these are the numbered categories and who falls into them. The reason it's important to know that they even exist is that the reality is that Congress has created a system where people with certain relationships to U.S. citizens or lawful permanent residents get priority in terms of how quickly they can immigrate to the United States. So the immigration law may sort of give priority to one or another group of people. But what you come to see is that for any of these categories, there tend to be relatively long lines of people waiting to be able to take advantage of these immigration benefits. And so if you take a look at page 72, this is the Visa Bulletin for June of 2009. And what you come to see is that, I'll explain to you what they mean, but you see there are all these dates, months, and years that are listed here, some of them going back as far as 1992. And what that may mean for someone is that they have to wait 17 years before they can immigrate, lawfully get their permanent residence in the United States. But basically, if you have someone with an immediate relative petition, they can apply to get their green card as soon as the application is approved. But if someone's not an immediate relative, they have to get in line behind all the other people in their preference category and wait for a turn. And so if you take a look at page 74 of the materials, this is a receipt notice for a child of an abusive U.S. citizen or lawful permanent resident. And what you'll see on there is that the application has something called a priority date of August 8th, 2006. And that's basically the date that this client's application was received by and put into the immigration system. So this is from a case about 3 years old. What you see from here is that his priority date is August 8th, 2006. And it shows that he is a child of an abusive U.S. citizen or LPR. In this case, what you'll see is that the child, in this case, is a child of an LPR, so he falls in something called the preference category 2A, which is explained on the visa petition. What that means is that he's in category 2A, his priority date is August 8, 2006. So we look at the chart on page 72, and what we learn is that he is from Mexico. So the priority date that's current on that case, if you look at category 2A and you look at the country of Mexico, you see that right now the priority dates that are current there are priority dates anywhere from May 15, 2002 back in time. So what you basically see for this client is that he may have a wait time of about 4 years before he can even apply to adjust status to a lawful permanent resident. And what you'll notice is, and it's not guaranteed it'll be 3 years, it could be a little quicker, it could be longer. But what you'll see, for example, is if you look at the first, on page 72, the first preference category for people from the Philippines, so that's unmarried sons or daughters who are 21 or over of U.S. citizens. You see that people with priority dates of September 1st, 1993 and earlier are able to adjust status. So if you have someone with a priority date later than that, or with a prior date that is very recent, they could be waiting something like 16 years before they're ever eligible to apply for lawful permanent residency. So you can see why in some of these cases, even if you're working with families where maybe 1 or 2 people have status, family-based immigration may not be the quickest or easiest way to resolve people's immigration issues, because if they have to fall into one of these preference categories, they could be waiting for an incredibly long time. The other thing to know about is that I think I mentioned earlier that children who are eligible for SIJS, they get sort of a special exception, and if they enter the country without permission, they can still apply for residency here. That's not the general rule for most people, and most people who immigrate through family-based immigration. So if you have come to the country with permission and meet a few more requirements, you may be able to stay here to get your permanent residency. But if you came here without permission, and if no one filed an early visa application for you, then you're not going to be eligible to adjust your status here. You're going to have to leave the country, go back to your country of origin, and wait for permission for the government to allow you to come back in. But it is incredibly hard to do because the law is set up in such a way that people who came here and stayed here without permission for a certain amount of time face very lengthy bars to returning legally. And so in certain cases, if people have been here 6 months or more, a year or more without permission, they may be barred from 3 or 10 years from ever returning to the United States. And so while family-based immigration is an option for some people, it may not solve all of their immigration problems because of all the waits and because of the bars that pop up for entry without permission or being here without permission. Okay, so the Violence Against Women Act is a form of immigration relief, and the reason why it's helpful to have now the 10 minutes of family-based knowledge you have is that the Violence Against Women Act form of relief, and again, it's not just for women, men can qualify, boys, girls, but the legislation that created the benefit is the Violence Against Women Act. And the thing that's important to know is that the Violence Against Women Act is designed to help people who have abusive U.S. citizen or lawful permanent resident spouses or parents to immigrate without the help of the abusive spouse or parent. So it's basically operates on a family-based model. In order to qualify for VAWA, you have to have, for a child, needs to have a parent who is a U.S. citizen or lawful permanent resident. And if so, the child may qualify to go forward with her own immigration process without having the abusive person involved in the case. Now, whether the abusive person is arrested or not arrested or at large, typically in family-based cases you need to have the cooperation of the person with lawful status. And it is also the case that in many situations of domestic violence, undocumented spouses may stay with partners because they're concerned about their immigration status and there are threats that they may be turned over to the immigration service or the like. So Congress created this benefit to sort of help people who could otherwise go through family-based to get around the reliance on the abuser. But still it's important to remember that you have to have this relative who is a U.S. citizen or a lawful permanent resident.
What do you, how do you document or what has to be known for violence? I mean, can you just say that I live with an abuser, like I have to be?
The question is about what kind of evidence do you need to establish this abusive situation. Well, I'll go over this, but the answer is that there's a special unit of the Immigration Service at a place called the Vermont Service Center, and they are supposed to be specially trained in dynamics of domestic violence and domestic violence issues, and they're the ones who adjudicate these petitions. There's no requirement of physical abuse. It can be psychological abuse, it can be emotional abuse, it can be viewing the abuse of others that translates into your abuse to you. There's no requirement that you have police reports. There's no requirement that you have restraining orders. Now, the more evidence you have like that, the more helpful it will be. But there are certainly cases where people's petitions have been approved on credible personal statements. And the immigration laws and immigration service recognize that in a lot of cases of domestic violence, people are fearful of reporting to the police. They don't want to get a temporary restraining order. They're worried about their own safety. They may still be living with the abuser. And so there aren't requirements that you have all of this documentation, but often there's usually something, medical reports, if the person's been hospitalized, the child has been injured, if there are juvenile court reports, those can be really helpful. But you could have a statement, and that may be enough to meet the requirements. One thing to know about the Violence Against Women Act, U visas, T visas, that's a little bit different than special immigrant juvenile status, is that generally speaking, those applications are filed with the Vermont Service Center. They're adjudicated in Vermont. And the general CIS policy is to not put people in removal proceedings if those applications are not approved. Now, you can never tell a client with 100% certainty that's not going to happen. But the general rule there is that if for some reason an application is filed, it would be very rare that a person would be put in removal proceedings if they didn't qualify. And I think that's usually the case when someone has an extensive criminal record or there are other really negative facts in the case. But it's a little bit, in terms of risk, it's sort of a diminished risk, I would say, than probably SIJS because of the location of the adjudication and the general policy they have. But the requirements for SIJS I've listed up here, and I'm not going to go through them like I did. I mean, requirements for VAWA, I won't go through them like I did for SIJS. But just for you to see that, again, there's the important requirement that there has to be this U.S. citizen or lawful permanent resident parent, and the child has lived with this parent in or out of the U.S. and is currently here. The child has to be unmarried and 21, although there are protections for children who file before the age of 21. And if you can show a connection between the abuse or if it's a case of incest, the deadline will be extended to 25. The child has to show that she has good moral character, and I mentioned that really briefly before in the naturalization context. But again, it's sort of showing that you aren't statutorily barred from good moral character, and then showing that you merit a favorable exercise of discretion. And then the last requirement that they need to establish is the child has suffered abuse, and that has to amount to battery, extreme cruelty. But there are not clear definitions of what battery, extreme cruelty mean, but it is clear that it doesn't require physical abuse and that the documentation can be any credible evidence. The application process, again, is the same form that you have in your packet for special immigrant juvenile status. The I-360 is also used for the VAWA self-petition. That's filed with the Vermont Service Center. And once or if that application is approved, then how quickly someone can move to get their green card depends on, again, whether they have this relationship to a U.S. citizen or whether it's to a lawful permanent resident, whether they're stuck in a preference category or whether they can immigrate immediately. So if you have this qualifying relationship to a U.S. citizen, then you may be able to file for a green card relatively quickly. But if you have a child who falls into a preference category, they're going to have to wait, like everyone else, to eventually be able to apply for their lawful permanent residency. The one benefit of going through VAWA is that the child may be able to get a work permit during those years and years that they're waiting to apply for their permanent residency. So there is that benefit. But again, it can drag on for quite a long time. And it doesn't address the situation, again, of children who have undocumented parents or, are in abusive situations with people who don't have lawful status. One thing to know that in the chart that I pointed out earlier on the federal benefits for people by immigration status, there are definitely increased benefits for people who have approved VAWA self-petitions. And that is also designed to help people in abusive relationships to get in situations that may make it easier to support themselves, support their children, get out of those situations. Again, if you have a parent who's been abused by a U.S. citizen spouse or lawful permanent resident spouse, a child can be included on that VAWA I-360 petition. So even if the child herself was not necessarily abused, you may be able to include the child on the parent's VAWA self-petition. Okay. All right. And again, as you'll see, we're going through those pretty quickly, and it's just to really give you the very most basic requirements, sort of understanding that there's something that something may be out there if you run into these situations. The UVisa we'll talk about in a little bit more detail, and there are some examples in the material. If you open up to page 83 in the materials, what you'll see is that I've reproduced the statute and the regulations that govern this form of immigration relief called the UVisa. And the UVisa, has anyone here ever heard of a UVisa? I know at least a couple of people have, but has someone's heard of it? Has anyone worked on a UVisa case before? No. So the UVisa is about 9 years old. Again, it's immigration benefit that not a lot of people know about. It is the case, though, that in Nebraska, quite a few immigration legal services providers do have experience doing UVisas. So this is not one where, even though a lot of people may not know about it, you're not going to be out without some kind of support, because there are plenty of organizations that have done UVisas before. And basically, it's an avenue for undocumented children, but also adults, but I'm focusing on kids, but adults who've been victims of serious crimes and who cooperate with law enforcement. And they are able to gain temporary lawful status, and then they're put on a road to gaining lawful permanent resident status. Now, the requirements for the UVisa are not terribly numerous, but if we're talking about kids, the child needs to have suffered substantial physical or mental abuse as a result of certain criminal activity. And on the next slide, I'll show that there are a long list of enumerated crimes the child could be a victim of. But sometimes we'll screen a case and I ask a child, have you been the victim of a crime, and they got their backpack stolen or something happened and it was a crime, but they may not fall into the UVisa eligibility requirements. They need to show this substantial physical or mental abuse, which I think really is more harm, and then also that it has to be one of these enumerated criminal activities. The child needs to possess information about the criminal activity, and the child also has to provide a certification from law enforcement, and this can be local, state, or federal law enforcement, that the child is being, has been, or in the future may be helpful to the investigation or the prosecution of the crime. and then again that the criminal activity took place in the U.S. or that it violated U.S. law. Now, if the child is under 16 when the crime happened, then the requirement that the child have information about the crime, or the requirement that the child be helpful in the investigation or prosecution, is not required of the child, him or herself. You can get a parent, a guardian, a next friend under the regulations to fulfill the information, the helpfulness requirement. And so what you can see from the basic requirements is that the UVisa may be an immigration tool that may be helpful in cases where, say, you have domestic violence situation, but the abusive person is not a U.S. citizen or isn't a lawful permanent resident. So you can't apply for VAWA for that child because they don't have that qualifying relationship. But in the UVisa context, even if the abusive person is undocumented, or has a temporary status that doesn't match up with lawful permanent residence or U.S. citizenship, that child may nonetheless qualify for a UVisa for the same kind of conduct, because the UVisa doesn't depend in any way on the immigration status of the person who inflicted the harm. And even if the person who inflicted the harm is actually unknown, it was an assailant who raped someone or assaulted a child and has disappeared, if that is reported to the police and the child is helpful or the parent is helpful in whatever way they can be, even if the person is never apprehended, even if a criminal case is never filed because they can't locate the person, that may still qualify the child for a UVisa. There is no requirement that there be a conviction or a sentence. The requirement is really focused on the helpfulness of the victim, because the idea behind the UVisa was that it was designed to help people who've been victims of crimes come out and report the crimes and try to help have the crimes investigated and have perpetrators arrested. And so that's why the law enforcement certification is required, because you need a law enforcement agency to verify that the child is actually being helpful with the investigation. So it's not like a VAWA where you can just submit a statement saying, I'm being helpful. There needs to be a law enforcement certification of that helpfulness. Now, these are the crimes that are covered, and you'll see in the statute that we reproduced, they're listed there. They're not exclusive. You can see that in addition to all these listings of horrendous crimes, there's also similar activity in violation of federal, state, or local law. I underline here the ones that I thought might come up most likely in juvenile cases, but any of these enumerated crimes would qualify someone for a UVisa. And again, it's important to remember that if you have a family, you may not have a child who's a victim of one of these crimes, perhaps, but you may have a parent who is, and that parent could include the child as a derivative on their UVisa application. So you could have a parent who's a victim of a crime, and the child could be included on that application so that the immigration status of the whole family could be addressed. Similarly, if you have a child who's a victim of a crime, that child may be able to include a parent, could be able to include a sibling who's under the age of 18 on the UVisa application. Now, the child cannot benefit the abusive parent. So if you have a parent perpetrating harm against the child, the immigration law doesn't allow that child to help that abusive parent, but the child can help a non-offending or non-abusive parent to qualify for a UVisa as well. Now, this is where I think the juvenile court role and people in juvenile court can do quite a bit with the UVisa, is on this law enforcement certification. Just like in SIJS, where you can't file unless you have these findings from juvenile court, in a UVisa case, you can't file unless you have a signed certification from law enforcement. So if you look in your materials at starts at page 75 and goes to page 77, you'll see that there's a special immigration form that's called the Supplement B, I-19 Supplement B, a UVisa, U non-immigrant status certification. This is a special form that needs to be signed by law enforcement, and this has to be submitted with the immigration packet. And if this certification is not signed, there's no UVisa to be filed. Now, the thing that's important to know is that not just anybody can sign a certification. Not me, not probably most of the people in this room. But what is important to know is that the law does define who has the ability to sign these certifications. And the regulations state that it can be federal, state, local law enforcement agency. It specifically lists prosecutor, it lists judge, it lists other authorities, and it also specifically includes Child Protective Services. So Department of Health and Human Services here, under these federal regulations, is clearly a certifier for a UVisa. You can have certifications filed, and signed by Child Protective Services you can have someone from HHS who could be designated to certify these cases. When I called people around who handle UVisas, I tried to find out, has anyone gotten certifications from Child Protective Services or gotten them from a juvenile court judge, because a juvenile court judge is in a clear position to sign certification. And what I learned was that no one had done that yet, but that they had succeeded in getting certifications from different individuals, including police chiefs, including county attorneys, and also including designated people within the domestic violence victims unit at the AG's office, state AG's office. Now, the thing to remember is that it can't just be any person within a certifying agency. It can be any judge, that's clear. But it can't be any caseworker within HHS or any particular police officer. The person who signs these certifications has to be either the head of the whole agency, and I've learned that I think in Lincoln, the police chief is the certifying official, and he is actively involved in this, and he is the guy. He hasn't designated that to anyone else. But it can be the head of this agency, or it can be a person in a supervisory role who has been given sort of approval to sign these UVisa certifications. And as long as the person is with a certifying agency and they've been designated or are the head of the agency, they're able to sign these certifications. And we've definitely, I don't know of any certifications signed by HHS here, but I do know that in other places, folks have definitely been successful in getting certifications from Child Protective Services. Where we do our work, Child Protective Services actively came to us to ask if we would be willing to do the immigration part of these cases. They screen cases, they sign certifications, and they send the cases to us to be filed with the Immigration Service. So that's a very sort of model of very proactive agency trying to address these immigration issues. But either way, the Immigration Service has approved cases. We recently, last week, had a UVisa case approved for a child who had a certification filed by Children and Family Services. And it was actually for a case that where the child abuse, it was horrendous abuse, and it happened about 10 years ago. There's no time limit on the crime. I mean, there's no time limit on how quickly you have to get the certification or how quickly you have to file it. It may be much more difficult to get certifications on cases that are old because the person who was familiar with the case or could verify that the child was helpful may not be around anymore. So certainly, it may be easier to do it on more recent cases, but the thing to know is that the application to the Immigration Service has to be filed within 6 months of the certification being signed. So if you are planning on helping with a UVisa or someone's asking you to help with a UVisa certification, the thing to remember is that there is some timing involved, that once a cert is signed, it needs to be filed within 6 months. It doesn't mean that someone can't re-sign a cert if it's past 6 months. But it's just something to know that unlike SIJS, where there's not a time limit on filing, there is for the certifications. And the process of getting the, and again, that goes to sort of the when you can get the certification. Like I mentioned, you don't have to wait for a conviction, you don't have to wait for sentencing. You just have to wait for the law enforcement agency to make a determination that the child has been or is being helpful, or to make a determination that the child will be helpful in the future. In the juvenile court system, there are probably a lot of different ways that certifications could get signed. I know that guardians ad litem or defense attorneys could approach HHS to sign certifications, or county attorneys to sign certifications. I know that in certain cases, county attorneys take the initiative to get the certification signed and to pass them on to immigration practitioners. It's also possible to, if you're asking for a certification from a judge, to file a motion for a certification. And so starting on page 78 is a motion that I wrote, because I don't know that anyone ever filed one before, but I wrote a motion asking for a certification from a juvenile court judge on a case of child abuse. And I've changed the facts a little, but you'll just see that it may be helpful if you're working on one of these cases to take a look at it, because it sort of goes through the UVisa eligibility requirements and explains why the child should qualify, but also why the juvenile court judge himself was in a position to sign the certification. And so this case did get the certification signed, and it is on file. And I think that one of the legal services agencies I talked to told me that they often get their cases from the state AG's office, that the state AG's office will contact them, or county attorneys or prosecutors will contact them with cases that they'd like to have UVisas filed for. The process, again, is just that immigration application is going to get filed, again, with the Vermont Service Center. and the child has to have biometrics taken, and then if the UVisa application is approved, the child is given a work permit and sort of protected status for 4 years. One of the benefits is that the child can qualify to file for lawful permanent residency after 3 years of continuous presence in the U.S. after having the UVisa approved. So for some cases where you may have a child who might qualify for VAWA, but they could qualify for a UVisa, someone with expertise on immigration probably should take a look at the case. There's no rule that says you can't file for both, and in some cases, one or the other might be quicker. If you have a child who's going to have to wait 10 years to apply for permanent residency because they're in a strange preference category through VAWA, it could be a case where doing a UVisa may be a better option because the process, although you have to wait 3 years, would be quicker than some other immigration options. And then again, like I mentioned, this is a case where you can have a child who can help a parent or sibling on a UVisa. Similarly, you can have a parent, if they're qualified for a UVisa, can include their child. So in the case that I did, that this motion is based on, the child is the principal UVisa applicant, but then the parent, the non-abusive parent, was included, and the child's sister was included. So there are 3 applications all tied up in a single certification. And there are no limits on the number of people as long as they have those qualifying relationships to the child that can be included. So it's a really, I think SIJS and the UVisa are really the kinds of immigration relief that probably have the closest connection to proceedings in juvenile court, at least as much that they can, the findings from the court proceedings can help the child with the actual immigration process. But again, if for some reason you don't get a certification from Child Protective Services or from the juvenile court, you can always try to do it from the police officers or other law enforcement officials. Yes?
Is legal entry required for an adult?
The legal entry is not required for an adult, and this is a case where a lot of the waivers of inadmissibility are even broader than they are for special immigrant juvenile status, and where unlawful entry is not a bar to this kind of relief. So I would say that the ones where, the forms of relief where those kind of bars are least applicable are the SIJS, UVisas, and T visas that I'll talk about. But again, also for the VAWA cases, lawful entry is also not a requirement there either. And that's being sort of recently worked out. But usually on these forms of relief that tend to be generous for a relatively small population, those kind of bars tend to be reduced or gone altogether. So if you have a person who entered without permission, that should not bar you from inquiring into these kinds of relief. Let's go back. There were a couple of changes from that recent legislation on the UVisa. Since people haven't done them before, you don't have to worry that you're going to get confused about which universe you're operating in. But the thing that's important to know is that the recent legislation also waived all the filing fees for these cases. So there are large filing fees for all these applications, but people can get fee waivers for those as well. So the cost of applying shouldn't be a barrier. Fee waiver applications can be filed and tend to be granted pretty regularly. Okay, T visa. A T visa is a kind of immigration relief that is available for kids who have been victims of severe forms of trafficking in persons. And like the U visa, it may give them temporary protected, or not temporary protected status, but temporary legal status for 4 years, the right to apply for lawful permanent residency after 3 years. I think that T visas tend to be very rare, and I think part of that is that people who are like victims of severe form of trafficking in persons are under-identified and relatively difficult to find, even though they're here. There have been estimates that every year around 14,000 people are trafficked into the United States, but very few of them are ever identified by law enforcement or by people in the child welfare system. The requirements for a T visa are pretty clear, and it requires that the child has to have been a victim of severe form of trafficking in persons, which can be for an adult sex trafficking through fraud or coercion, but if it's sex trafficking for anyone who's under 18, that's going to qualify as severe form of trafficking in persons. It also, you'll see, involves recruitment, harboring of a person who's here, and they use terms like involuntary servitude, slavery, peonage, debt bondage, and they may seem sort of antiquated terms, but basically what you're talking about is kind of modern day slavery, people who are kept in situations often of domestic service, forced into work in factories, people who are kept in houses of prostitution. I had a client who was only 16 who was brought here and forced to work in a brothel and then locked in the basement during the day. And we eventually got SIJS for her, but she also should have qualified for a T visa. And then the child has to be physically present here on account of the trafficking or here to assist in the prosecution or investigation. And then you also have to show that the child would suffer extreme hardship upon removal. And so the hardship can consider a lot of things: the child's age, what kind of harm they've suffered, any kind of services that might be available to them back in their home country, but also dangers that the people who traffic the child might retaliate against them in a place that has reduced law enforcement. The child has to submit an application again to the famous Vermont Service Center that adjudicates these happy cases. And again, we'll have biometrics taken, and if approved, can get will be able to get a work permit, and also after 3 years can apply for lawful permanent residency. And this just shows there are actually quite a few government benefits that are available to trafficking victims. And if you, on the chart that I gave of the federal benefits, what you'll see is that for a lot of benefits that very few people who are not residents qualify for, trafficking victims tend to qualify for nearly everything. One thing that's important to note is that, this is for those of you who work at, I guess, at HHS, there is in the recent legislation from December of '08, there's a note that any agency that discovers that, that they have a child who may be a trafficking victim has to report this to U.S. Health and Human Services within 24 hours to their, and I have a phone number and an email that I can share with you. But the federal government is very interested in early identification of trafficking victims, in part to assess their eligibility for benefits and to get them into programs that may, whether they're medical needs, whether they're psychological needs, different government benefits that are available. So that is a requirement that was created recently that I don't think a whole lot of people know about. The phone number, in case you need it, is 202-205-4582, but if you run into this, you can always call me. On the benefits of the T visa, like you'll see, the person may be eligible for sort of a wider range of government benefits, can apply for permanent residency. And then another thing to know is, like the U visa, it's a kind of relief that can benefit more than just the victim of the trafficking, that there can be family members who are included as derivatives. So if you have a child whose parent is a victim of trafficking, but the child maybe wasn't trafficked herself, maybe she arrived later, you still may be able to include the child on the parent's T visa application. I will say these are very rare. I don't know that they'll never come up, but they're not as common to see as maybe the U visa and the SIJS cases are. And again, there were a few changes from the recent legislation about work permits, about federal benefits, and also about fee waivers available for Ts. Okay. Now, the last thing I'm going to talk about really briefly is asylum. And again, I just want you to know that this is not the whole world of immigration benefits. There are a lot of other kinds of immigration relief that may be available to people. The ones that I'm going over are the ones that I think are most likely to crop up on cases of families or children who are involved in juvenile court. But I'm not giving you the whole world of immigration, but the ones that I think may come up most likely. Asylum is a kind of immigration relief that's available to children. It's also available to adults, who I mentioned earlier today. They're kids who have a well-founded fear of persecution in their home country because of their inclusion in a group or a protected group. So they have a fear of persecution on the basis of political opinion, social group, race, religion. They may qualify for asylum. And the requirements are this well-founded fear of persecution. It's actually really challenging and kind of interesting to do asylum cases for children because there is an objective and a subjective component to this well-founded fear which is required. And so I actually really, they're very sad cases. I enjoy doing the case. They're legally really interesting because there are a lot of questions about what kind of subjective fear would you expect a child of 5 years old to have when they have no real concept of what conditions may be back in their home country. Asylum cases tend to be pretty difficult to win. If you have an SIJS case where the child looks eligible, you have the findings, unless something untoward happens, you can probably not guess, but see that it may be more likely than not the case will be approved. With asylum cases, the approval ratings are not, they really vary by asylum office, and they vary by immigration judge who adjudicates the case. So for Nebraska cases, all the asylum cases are heard out of the Chicago Asylum Office. And so there are stats that are available. If anyone's interested, I can give them to you. about the approval rates for the Chicago asylum office, but you should just know that the offices across the country really vary, and that immigration judges who adjudicate asylum cases also have really varying rates of approval. So it's not the kind of relief that we really recommend that people file for affirmatively unless someone with experience in asylum has assessed the case and thinks that there's a very strong case. Because unlike the U or T or VAWA, if you apply for asylum and you're not granted, the chances are very high you will end up in removal proceedings. And it can be very difficult to prevail on these claims. So it's not to say that we help people all the time to file affirmatively for asylum, but it's not the kind of case that you would sort of roll the dice and file for folks because the consequences are really high and the requirements tend to be pretty stringent. And so you'll see here there's a discretionary component. The child must not have persecuted others. The persecution has to be by the government or by a group that the government can't control. And there's actually sort of interesting and developing case law about domestic violence and whether domestic violence in a home country may be a basis for a child to claim asylum. So there have been legal arguments made and cases that have come out about that. Generally, those are cases, I think, that advocates are representing children who are already placed in removal proceedings, and I think it's less likely that affirmative applications are made with those kind of cases because the legal basis is a little bit more complex. For kids who are not in removal proceedings, again, affirmative cases are filed with the Immigration Service, and for all of Nebraska, they're set in Chicago. If the child's not granted asylum by the Chicago Asylum Office, they won't technically be denied. They'll just be referred to immigration court to let an immigration judge have a second shot at adjudicating the application. Again, if you have a child who's in removal proceedings, then generally the place you would file for kids is in immigration court. But the Trafficking Victims Act that passed at the end of last year makes some positive changes for kids on asylum cases. One of the major changes is that to apply for asylum, you have to do it within a year of your arrival in the U.S. But now if you have a child who's considered an unaccompanied minor, and that's a child under 18, no lawful immigration status here, and no parent or guardian to provide care and custody, then that child is exempt from the one-year filing deadline, which is a help. The child also can now go to the asylum office for their asylum adjudication, even if they're in removal proceedings. The general sense is that the asylum office is better equipped to deal with children's asylum claims, and so kids who are in removal proceedings still get a chance to go before the asylum office and have an asylum officer in a non-adversarial setting adjudicate their case. And that's been something that people have advocated for quite a while. And then the government is also supposed to promulgate regulations that will deal with special procedures and special substantive issues that come up in kids' immigration cases. But they have, this is very new, they have yet to do that. So there'll be a regulatory process for those cases. Okay, so we're going to go next to the Immigration Consulate of Juvenile Delinquency Dispos. But before we do that, we're going to do two things. One is to give you guys a chance to try to see if you can figure out some of the hypos, and then the other is we'll take a break after that. So if you open up your materials, you'll see, definitely don't take the blue paper, take the pink paper that says immigration relief, and there's 3 hypos on there, and you should turn to your friends at your table that you're sitting with, and if you're not sitting with someone at a table, you can go to another single person, and we'll take probably about 10 minutes to talk about them. Don't feel like you have to get through all of them, and it's not a test and it's not a quiz, but just try to see if you can figure out and use the PowerPoint to sort of answer the questions on the hypos. And then what we'll do after about 10 minutes is come back and I'll get your thoughts and then also give you my thoughts on the hypos.